Good evening. Thank you for hearing my testimony. My name is Pamela Eisinlaw. I am a mother and a defendant and appellate in a self-represented party in my family custody case. In 2003, I had been married for a number of years, and I had a one-year-old child at that time that was diagnosed with systemic rheumatoid arthritis. And she was very ill, and I was taking care of her at the time. I also had some domestic violence issues, and police were called. DCF was involved because I made the call, and my ex refused to cooperate with DCF. I took our daughter and a backpack and the laundry basket and my pets, and I left. I left my home, I left a business, and I moved in with my mom just across town. We've been in the court system for, I did hand in written testimony. Yes. In 2010, after literally being in the court system for nearly 10 years, I had our presiding judge proclaim that we are pretty much the largest family custody case in Litchfield. And in the last orders that he issued, he stated that our file is about 5 files thick. I just filed my second appellate appeal. In 2010, going back, my daughter walked into her school after hearing a lesson on the word worry, after being with her father for 4 days, went to her teacher privately and asked her to take her aside so she could talk to her privately. She took off her sweatshirt, and she had bruises all over her, and claimed that her father beat her up. The social worker, she was involved in a lunch bunch group with kids. I knew that she was having some issues, and we were also had her in therapy at the time. We were also at that point in time had already been through an evaluation with Connecticut Resource Group, Dr. Krieger. We were ordered to that. Our GAL is Dina Menchetti.
Is that an attorney or a mental health person?
Dina Menchetti is the GAL.
I know, but is she by profession an attorney or?
She's an attorney and GAL.
All right, thank you.
She's been on board since 2008. She was also ordered to us. In 2010, after this lesson, my daughter talked to the teacher privately, talked to her social worker, talked to the school nurse, principal, and music teacher, and made this disclosure. The school reported that my daughter had made that report to her teacher, and DCF and the police were involved within hours. Earlier in 2009, and I know I'm kind of jumping around a little bit, our evaluation with Dr. Krieger was approximately $5,000 at that point in time. The GAL had reported to DCF that earlier, a year earlier, that my daughter was having issues claiming abuse by father. She reported to DCF. A year after that, my daughter's therapist at the time reported to DCF during a session with my daughter that my daughter was disclosing abuse, and she reported to DCF.
And Ms. Eisinlaw, I'm going to ask you to kind of see if you can jump to the conclusion, please.
Well, sometime later, the GAL recanted once my daughter made this third allegation through her school. She basically flipped her position and decided that I was the manipulator. I have been accused of parental alienation, and my daughter was removed from my custody nearly a month before the DCF report was even issued. I have since been in supervised visitation. He's changed visitation agencies 3 times. I've been in with 2 therapists and have had no issues. My ex did go in and pull releases on the evaluator, Dr. Krieger, and also pulled releases on my child's therapist because she disclosed to DCF. My daughter was without any therapy for nearly 8 months. We were ordered back to Connecticut Resource Group. And mind you, just backstepping a little bit, is that once those releases were pulled, nothing could transpire for my daughter with the evaluation. That was $5,000 down the tube. That never came to light. And I had been through all of these supervising visitation places that were favorable to me. They never found any issues whatsoever. And yet, at this point in time, we were ordered to reunification therapy, finally, after a year of not seeing my child. It has now been 17 months. The last order on a re-argument was that because my daughter would not get out of a car, I pretty much have lost everything. I have no access at this point to my child except for an occasional incoming call from her, which I got one tonight when I was sitting here. But I stayed here because this is important. Our systems are broken. And at this point in time, the only recourse I have is to go through a second appeal and hope by God that I will have some opportunity to at least see my child. One of the things that I was mentioned here in my written testimony was that one of the things was I am in favor of a shared custody of some sort, but shared custody may be a step up with the parallel parenting plans that really eliminate parents from this kind of behavior, withholding children. It really takes decision-making out. And with some of the things that this gentleman, Mr. Weissmuller, had mentioned before, and some of the other speakers in the audience, they really had some good ideas about a shared parenting plan. However, when you have situations like this where your child hates you and she's 9 years old, 10 years old, and now 11 years old, and you have no opportunity to see them, and everything has been cut off from you, and you have a judge who basically says, unless the kid wants to get out of the car and you sometime in the future get some sort of a phone call, I'm not going to order anything. So I'm at a standstill. The only reason I got before the judge, after being denied under Taft versus Belcher on many occasions for 6 months at a time, this judge was a presiding judge and had been looking over all of the motions that I had to file. That had to go through him first. With all the supporting evidence that I gave under my ex's word, GAL's word, reports from therapists, reports from evaluators, reports from supervised visitation people that were either favorable or not favorable, that showed their words versus mine, because I've also been victimized as the one who is causing my child to act this way.
Okay.
My child was loving.
Ms. Eisinlaw, please, can we get it wrapped up?
And to this day, she doesn't even crack a smile. And
Thank
her
you.
school is within 2,000 feet of my house.
Thank you very much.
I have a quick question.
Yes.
If she was complaining about abuse, and if you've been denied, who has custody of your daughter now, DCF? Or?
No, my ex-husband has sole and physical custody of my child at this point in time.
So what happened to the DCF and police investigation on abuse?
There were 3 or 4 reports, and none of them were substantiated except for the last one. The last one, both parents were substantiated as being emotionally neglectful to our daughter, even though I had taken her out of that situation. I can tell you that the child was removed from my care and sole custody was given on April 1, 2011. She was removed the previous November at the end of the month, right after Thanksgiving in 2010. At the end of April 2011, he was arrested. My ex-husband was arrested again on a domestic assault against his second wife.
And we have that in your written testimony.
Yes.
Thank you.
You do.
Thank you very much.
Other questions?
Do you remember it now? Okay.
I know, and I was sort of jumping all over the place, and I do apologize for that. It's been a long day.
Mr. Weismuller.
I apologize, and in no way am I making light of your situation. I can make light of my own mental capacity past 9:30. We've heard from a lot of people today that they've not had access. What I'm understanding is that it's alleged by the guardian ad litem right now that you were engaged in parental alienation, and
Yes.
even if we were to say, for the sake of argument, that there's some kind of a finding made by the judge, but I'm guessing it hasn't happened, that there's some kind of emotional harm that could have been caused. I'm not understanding where an order would have been entered to limit your access. You've been given an order that limits
Right.
your access.
Right. I was under supervised visitation, and in 2012, the supervised visitation order was vacated, and we were ordered to reunification therapy under the recommendation of the guardian ad litem, the child's personal therapist, and also the second and third supervising visitation agencies. And from that point on, it was a year where I had to stay with one supervising visitation agency. After a month, she told us that she couldn't do it. She wasn't qualified to do it. And actually, she recommended EMDR trauma therapy for my daughter sometime later on, and basically forced the issue to have the parents do right for the child. And that ultimately didn't happen. Almost a year later, the judge basically said to us, "What happened?" This was after almost 2 consecutive 6 months where I was not allowed to file. I've been, listed as a vexatious litigant. And he said to us that right then and there, "What happened? Why didn't this occur?" And I said, "It hasn't even started for reunification therapy." We did get, he did open up the door and allowed us to make presentations to him through memorandums, which we did do. And were assigned to a therapist in Canton to do reunification therapy. Later on, what happened with that is that my ex refused to cooperate with her. So I filed a motion for contempt again. And what happened was the judge ordered us to talk to Roger Freegon of Family Services before he would hear our motions. And it took us about 3 or 4 hours, my ex finally signed an agreement with this lady to have this reunification therapy. I've never met with her. That was in July. and September, she wrote an email back to Mr. Freegon and basically said that this is not going to happen. When she was with the therapist, she said that she would want to see her mother if her mother could answer questions. When she was with father and stepmother in the room, she said that she would refuse to get out of the car. And from that point on, I have no visitation, no therapy, no questions, no Christmas, no nothing.
But your order still allows for access and reunification therapy.
The orders have not been rescinded. The orders have basically been put on the child to make a decision on her own, I'm thinking, sometime in the future.
Thank you very much. We've heard that particular commentary a lot today, and it's very, very disturbing.
Thank you.